probate questions on Google that people also ask. This is the first video in a little mini series that we're doing on the questions that people also ask on Google. How much does it cost to execute a will? And I think there's a difference between actually executing a will and probating a will. The probating a will happens after somebody passes away. Executing a will is what you do during your lifetime, inter vivos, to actually create the will. So it really depends if you're going to execute a will while you're still living. It really depends on where you live in the United States. It varies substantially between different jurisdictions. And you've probably even seen online that there are some online places that will allow you to basically download a form and fill out the blanks and execute a will. I will tell you guys, while that is extremely inexpensive, it could cost your estate many, many thousands of dollars later on if that form gets it wrong or you fill that form out incorrectly. We actually had a probate in which somebody downloaded the form for like $49, I think is what they advertise. And I'm sure you know who I'm talking about. They downloaded it and they filled out all the blanks, not all of them, but they filled out the substantial important blanks incorrectly. And so we had a really, really bad will that I know did not say what the person actually wanted it to say or to make the distributions that they actually wanted to make. So the cost of executing a will, though, you can go that route. And I think, like I said, it's $39 or $49.99. You've seen them on the internet and you can download them. Or you can go to an estate planning attorney who will probably charge you several $100s to several thousands of dollars, depending on the complexity of your assets and everything that you have and what kind of distributions you want to make. Don't assume that you can just download something off of the internet and it's going to fix all of your problems. May not always be the case where you need to go to an estate planning attorney. I can't believe I'm saying that, but there may be cases where there is a very, very simple estate and that may be all you need. But check the form out, check with an estate planning attorney, make sure you have your distributions correct, make sure you have named guardians for your minor children in your last will and testament. What is the average cost of making a will? That's a great question, and we touched on it a little bit in the last question that people ask on Google. The cost of creating a last will and testament depends. Are you downloading something off of the internet? And I'm sure you've seen, if you're watching this video, you've probably done some of your research. There are places on the internet where you can download a form last will and testament that cost around like $39.99 or $49.99. I'm not sure of the cost, but it's around there. Your other option is you go to an estate planning attorney who has years of experience, who can create a last will and testament specifically tailored to you and to the assets that you have and the distributions that you want to make. So it's really up to you. You can go with the downloaded form off the internet if you really don't need anything else, or if your estate is a little bit more complex, you have several beneficiaries you want to make sure that they get distributions to, you want to make sure you name guardians for your children, then you're probably better off going to an estate planning attorney who is probably going to charge you a few $100s to several thousands of dollars. Now, again, depending on the complexity of your estate and your distributions, it may take that estate planning attorney at a minimum several hours to create the last will and testament specifically tailored to your wants and your needs. Then it depends on what the hourly rate is for the attorney or whether or not they do these as a flat fee. So you might see a last will and testament at an attorney's office anywhere from maybe $150, $200 to maybe around $700, $750, $900. It really just depends on, again, what you're looking for. And those are just kind of ranges. Again, it depends on the complexity of your estate and what kind of distributions you want to make. I have seen last will and testaments where they did not want to do a revocable living trust centered estate plan. They specifically wanted a last will and testament that cost several thousands of dollars. We made it exactly how the client wanted, and therefore it cost several thousands of dollars to draft the document that they wanted and they needed. Can executors get paid? Absolutely. Executors can get paid for the work that they do probating or administering a decedent's, your loved one's estate. Being an executor of an estate can take a lot of work. And that's why it's usually helpful to have a probate attorney assist you if you're an executor of an estate, because your job is to figure out what are all the assets, right? Bank accounts, real estate, cars. Are there valuables inside of the house? Did they have a Picasso up on the wall, or is it a fake? All of that stuff is charged to the executor to figure out what a value for all of the property is. In addition to that, they need to figure out what all the debts are of the person who has passed away. Did they owe Citibank? Did they owe Discover Card? Did they have a home loan? Did they have a personal loan? Did somebody owe them money? So the job of an executor can get quite extensive and can take up quite a bit of time depending on the estate and depending on how organized the deceased person was. If they were not very organized, then the executor and their probate attorney are probably going to have to spend thousands of dollars trying to figure out where all of the assets are. But if the person was very organized and kept everything very neatly in a notebook, then the job of the executor should not be as difficult because everything will be laid out for him or her and they will know exactly what they're dealing with. So to get to the specific question of can an executor get paid? Absolutely. And it depends on from state to state. Some do it on a percentage basis. Some will allow the executor to charge on an hourly basis, and it just depends on the jurisdiction. How much should you pay an executor of a will? Well, just like we talked about in the last video or the last question, they absolutely are entitled to get paid if they want to get paid or if you had laid that out in your last will and testament. But how much should they get paid? Well, it actually depends on the jurisdiction. We have seen jurisdictions across the United States be anywhere from 3% to almost 15% of the total estate. So in those higher end states, if there was $100,000 in assets, the executor could potentially be entitled to $15,000 to administer the estate. Now that's in addition to attorney fees and court costs. So remember that. The other thing you can do is you can actually lay out in your last will and testament exactly how much you want your executor to receive. And we've actually seen that a lot where people might have an estate of several hundreds, thousands of dollars. They will talk to a friend, maybe a third party, or maybe their son or child or a cousin, an aunt, an uncle, somebody, and they will ask them, will you be the executor of my estate when the time comes? And if you do, I will reimburse you X amount of money. And it just depends on what the person wants to pay the executor. We have seen a couple thousands of dollars. I think the highest one I've ever seen is probably around $20,000. But that estate was quite substantial. And they also wanted to, in addition to just paying them for being the executor, wanted to give them a little bit as part of the will. So a little bit of that was tied into that. To answer the question specifically, how much should you pay an executor? Again, it depends on the jurisdiction. In some jurisdictions, actually in most jurisdictions, if the executor is wanting to get paid, the court will specifically require that they turn in invoices just like the attorney might have to and show exactly what time they spent and what they were doing in that specific instance. If one day they went to the bank and spent 3 hours with a banker trying to decipher all the different accounts, then they can charge for that 3 hours at the bank. Their invoice might say something to the effect of, went to the bank to decipher different bank accounts. Again, it depends on the jurisdiction, but most courts require an executor to turn in invoices for the specific work that they did. And it could also be for travel. They might also have expensive copying costs, storage costs. There's a lot of expenses that the executor might have to maybe pay out of their own pocket until the probate is completed. And usually the court will allow those reimbursements. However, I should caution that I have seen where the courts will not reimburse other siblings. So let's say that Joey was in charge of being the executor and Joey turned in all of his invoices for maybe hotels, car rentals. They were needed to assist him in being the executor of the estate. Now, maybe on one of those trips, a brother or sister came and they also had hotel costs and meals. And I have seen where the courts have specifically said no to the sister or the brother receiving reimbursement because they were not the executor of the estate. So just be careful with that. The executor is absolutely entitled to get paid for the work that they do. If they want it, a lot of times executors will waive any sort of compensation, even their costs, just out of love for the person who passed away and to make things a lot easier for the other heirs or beneficiaries of the estate. How much does probate cost? This question we get daily. If we get 50 calls a day, I would say maybe 15 of those to 20 of those ask specifically, how much does probate cost? And you should be asking that because probates are expensive. Again, it depends on the jurisdiction because some states or jurisdictions have what's called summary probates or probates that can be done very quickly if there's not a lot of assets. But I will tell you that what we see on a normal basis is probates costing between $3,200 and about $7,500. And that is if everything goes absolutely perfectly. And by that, I mean, there's very little creditors, no creditors are fighting. The family members don't fight over the assets. It's just a very simple probate in which everything gets done by the statutory deadlines without any fuss from anybody. That is the cost of just a very normal probate, about $3,200 to about $7,500. If there's gonna be fights, if family members start fighting, then I can promise you, you can double, maybe triple that number because the attorney costs in having to draft motions, appear in court, draft responses to other motions are going to get very expensive very quickly. The best thing to do, have a plan ahead of time, talk to your family, and hopefully there's no fights so you can keep those probate costs down. Who pays for will probate? I know that question sounds funny, but that's the specific question from Google. Who pays for will probate? That is a great question because everybody wants to know how much it's going to cost them out of their own pocket to probate their mother or father's last will and testament. The good news is probates are paid out of the deceased person's estate. Now, last time I gave a range of about $3,200 to about $7,500 for a probate that goes very easy with no fights. That money is paid out of the deceased person's estate. It is not an out-of-pocket expense by any of the beneficiaries. I do need to caution that what will usually happen when you go to a probate attorney, they will most likely require a retainer up front to cover their costs and expenses during the probate. So let's say that the probate attorney requires a $5,000 retainer upfront to probate the estate. And the probate cost, for simplicity, exactly $5,000 for attorney fees, costs, expenses, publication, mail, everything cost exactly $5,000. One of the beneficiaries, usually the executor or the personal representative, probably put that on their credit card or took out $5,000 from their savings account to pay that retainer and put it into the attorney's trust account. What then happens is at the end of the probate, in the final account, that $5,000 is listed as an expense by the personal representative or the executor, whoever it is, and that $5,000 is taken off of the top. While that executor or personal representative may have had to pay the money up front out of their own pocket, they also get reimbursed that money up front off of the top before any other distributions are made. So that's a very important distinction. Why is probate so expensive? The simple answer is, well, there's a lot of costs and expenses that go into a probate. First of all, there are filing fees, and depending on your jurisdiction, it can be several $100s just to file a probate down at the courthouse. The next thing is, of course, attorney fees. We don't work for free, and depending on your jurisdiction, the attorney fees are probably going to make up the bulk of the probate costs. Just like I answered in the question regarding what it costs to probate, the attorney fees, costs, and everything can be from $3,200 to about $7,500, depending on your jurisdiction. It could be a lot more where you live. It just depends on your jurisdiction. The next cost is publication fees. One thing that people don't realize when you do a probate is there has to be a lot of publication of notices. In a probate, every time there is a hearing, the judge will issue an order for notice of that hearing. That notice of hearing has to be published in the newspaper, usually 10 days prior to the hearing. Now, in a probate, there might be 3 or 4 different publications. And depending on the newspaper and how many words are in that publication, it can cost you anywhere from $90 to about $180, $190 for each individual notice. The next thing that people don't realize is during a probate, the next thing is postage. Usually, especially if there is real estate, during a probate, just like we had to publish those notices, we usually always send notices to beneficiaries and other interested parties by certified U.S. mail. And that is not cheap. Every single one of those notices can cost between $7 and $9 depending on where we're sending it to and how much paper we are sending to them. So there's a lot of expenses that can go into a probate. That doesn't even take into account realtor fees, title company fees, auctioneer fees if we have to auction things off. Appraisal fees is another big one that a lot of people don't realize. If there's real estate involved, then we usually have to get an appraiser involved in the case. If there's personal items or artwork or cars that have some sort of value, we will usually always have to get those appraised as well. And I can tell you that that is not an inexpensive cost. So there's a lot of expenses that go into probating an estate, and that's why it usually costs so expensive. Like I said in the last one, about $3,200 to about $7,500 from start to finish. The simpler way, and maybe the less expensive way, is to get a revocable living trust centered estate plan set up so that your family avoids the probate process completely. Why is it good to avoid probate? It costs money and it takes a lot of time. If you don't want your family to have to spend a huge portion of your estate on probate fees, attorney fees, publication fees, mailing fees, appraiser fees, realtor fees, then avoid probate altogether. The other thing is it takes a long time. A regular probate is going to last you probably 4 to 6 months depending on your jurisdiction. We've had probates regularly go for over a year. There are extremes as well. We had one probate that was over 30 years old. That probate started before I was even in law school. I don't even think I'd graduated from college yet, but that's an outlier. That's an extreme case of a probate that just took way too long because family members did not get along. The bottom line is if you don't want your family to waste a lot of time and money that should be going into their pockets instead of to other people, then avoid probate altogether by getting a revocable living trust centered estate plan. How do you probate a will without a lawyer? Very carefully. Joking aside, I have seen many families go through the probate process on their own. And that is perfectly, absolutely 100% okay if they know what they're doing. The good thing is in most jurisdictions, you can go to the law library and usually find a book or two that'll tell you the exact steps to go through to complete a probate. The problem is a lot of those books will usually leave out a key element or they don't provide for what happens when something goes wrong, like family starts fighting. And that's where you can get into trouble. But can somebody probate a will without an attorney? Absolutely 100% yes. And we see that happen on a regular basis. However, what I also see in a lot of those cases, once they get about a third of the way through or maybe halfway through, they usually seek out the help of a probate attorney or a probate law firm to assist them with completing the probate process, because it can get overwhelming if you don't know what you're doing. Not to say you can't do it, but it can get overwhelming very quickly, especially when you're dealing with creditors, banks, your brothers and sisters, or the beneficiaries who all want their money yesterday. How do you avoid probate? Well, there's probably several different options, and it really depends on what your situation is. I always talk to my clients about different buckets. We have what's called a non-probate bucket, we have our probate bucket, and we have our revocable living trust centered estate plan bucket. If you have a revocable living trust, or trust, as you hear people say, the key to that is to put all of your assets into that bucket. In other words, all of your assets are titled in the name of your trust, so that when you pass away, your successor trustee steps into your shoes and is able to distribute assets and pay debts without having to go through the probate process. And depending on how complex your estate is, they may be able to complete this in a couple months at very little expense compared to a probate. The next bucket is, well, the probate bucket. That means you did not do anything. And so your assets have to be distributed by a court of law through the probate process. If that's the case, then it's going to cost your estate thousands of dollars and probably 4 to 6 months to get the process done. The other way to avoid probate is to be in that last bucket, which is the non-probate assets. Now, what goes into that non-probate asset bucket? Well, it depends on what you put into it, just like it depends on what you put into your trust bucket. If you have a bank account, for example, you could put a pay on death beneficiary on that bank account so that when you pass away, the bank automatically will pay whoever the designation is, whatever is in the account. So if you die with $2,000 in your bank account, the bank will write a check for $2,000 to your pay on death beneficiary. You can also do the same thing with real estate in some jurisdictions. It's called a transfer on death deed. So you could actually state when you pass away who you want your real estate to go to, but you have to make sure that that is up to date and you have it for all of your properties. Because if one of your properties is left out, then it will have to go through the probate process. The other items are like insurance or retirement accounts where you specifically list a beneficiary. So when you pass away, your retirement account or your insurance provider, your life insurance provider, they will look down and see who the beneficiaries are, and they will write a check out to those beneficiaries without having to go through the probate process. Now, I need to caution you here, because if you don't list anybody as a beneficiary of your retirement account, or maybe even your insurance account, then it's going to have to go to your estate and will then need to be probated. So ways to avoid probate are: 1, make sure that you have stuff titled correctly in your revocable living trust, or have stuff in that non-probate bucket and have them titled so that there's pay on death and transfer on death designations, and you have beneficiary designations as well. Whatever you do, make sure you speak with an estate planning attorney in your jurisdiction to make sure you do all of this correctly to avoid probate. How long does probate usually take? It depends on what jurisdiction you live in. Here in Oklahoma, we see probates normally between 4 to 6 months. And that is because if you look at the statute and the statutory timelines, if everything goes perfect, then you're usually done within that 4 to 6 month process. However, if there's going to be fights or somebody joins in or a creditor comes forward that wants to argue about one point or another, then that probate process, the length of time that it takes to probate, could get extended very quickly and take much more than 6 months. In other jurisdictions, I have also seen it take 6 to 9 months to get a probate done. So it really just depends on where you are and whether or not, like I've said in other videos, whether or not your family is going to fight over your assets. Even in Oklahoma, where it might only take 4 to 6 months, if people start fighting, I guarantee you're looking at least a year. And the more time it takes, the more attorney fees and other costs are going to be attributed to completing your probate. What are 3 reasons a person might want to avoid the probate process? The first is, well, it's expensive. Like I've talked about in other videos, a very simple probate can cost anywhere between $3,200 all the way up to $7,500 if everybody is getting along. People start fighting and you probably are guaranteed to either double or triple the cost of that probate. The second reason to avoid probate is, well, it takes a long time. It can take 4 to 6 months in Oklahoma, and from my understanding, it can take up to a year in other jurisdictions, again, if everything goes smoothly. And the third reason to avoid probate is it's a public process. Anybody with access to the internet can get online and find out exactly what your assets were, what your debts were, who your beneficiaries are, usually the addresses of your beneficiaries. It's not a private process. A probate is a civil lawsuit, and that means that everything in it is public. Anybody who wants to can get the information by like going down to the courthouse or just simply getting on their computer and downloading the pleadings and the inventories and the accounts that are in the probate. Who can be my executor? In most states and jurisdiction, anybody over the age of 18 years can be an executor of an estate. Also, in most states, an executor or a personal representative cannot be a convicted felon. That's very, very important. Who can be my executor? Well, almost anybody can be the executor if that's who you want to serve as your executor or personal representative in some jurisdictions. Those 2 words are used interchangeably, executor and personal representative. But yes, anybody can be your executor or personal representative as long as they are at least 18 years old, and usually in most jurisdictions, they cannot have been convicted of a felony. When you're an executor, you have a fiduciary duty to the estate to make sure that everything is done absolutely correctly, and you're in charge sometimes of a lot of money. So in most jurisdictions, if you are a convicted felon, that automatically disqualifies you from being the executor of an estate. And it really just depends on who you want to be the executor of your estate. It needs to be somebody that you trust implicitly to carry out your wishes exactly the way you want them carried out. You don't want to get somebody to be your executor if you know that they're going to be easily swayed or influenced by another family member or maybe a third party. You need to pick somebody who is strong and will be steadfast and that you trust implicitly to follow your wishes. I know I've thrown a lot at you today, so that's why we've prepared our free guide on estate planning. I'll put a link to it in the description below and in the comment section below that so that you can download it and get started in the right direction. And to help you out even more, watch this video up here and this video up here. If you enjoyed this video, then guys, please smash that subscribe button and click on the like button. And also click on that little bell so you'll get notified every time we post a new video. Have a great day and an awesome week. And as always, thanks for watching.